Hello and welcome to the Rogers Brief for March 7th, 2025. I'm Adam Rogers. Thank you for watching and thank you for listening. It's the first day of March break for Nova Scotia students anyway, so to all those that are celebrating, hope you have a great March break. For those that are traveling, hope everything goes well. This has been the first Rogers Brief for a little while. I've been on a bit of a break, but I have a strict policy whenever there's a big federal court decision on the authority of the courts over the Prime Minister in decisions of prorogation. Whenever there's a question as to whether that prorogation decision or advice to the Governor General is appropriate and can be reviewed by the courts, well, I just have to come in and make some comments on that. So I am going to talk about this decision. Came from the federal court. Chief Justice Paul Crampton delivered the decision yesterday. Made some news by agreeing that the Prime Minister had the right to request the prorogation from the Governor General and that the court was not going to overturn that decision. So I'll talk about that a little bit and what went into the decision from the federal court. Also want to talk about some Nova Scotia cases that are either in the news or came out this week in decisions. There's a couple of interesting social media related cases. One on a defamation case from a Facebook post back from 2016, and this was a nurse that was at the Nova Scotia hospital, and some comments on her treatment of one of the patients there. And the patient's mother made some Facebook comments, led to a defamation claim. We'll talk about that. Terrace and Meisner. And then there's a story in the news this week of an elementary school gym teacher, Steve Hutchins, and he's on trial now for a sexual assault allegation of a student from about 30 years ago, and a historical sexual assault case. We'll talk about that a little bit, state of that trial. So social media related there because there was a lot of Instagram posts that were, I think, fueling the allegations. So we'll talk about that some. There's an interesting immigration case decided by Judge Rhonda Vanderhoek this week, and it involved an Afghan citizen who has made his third attempt as a stowaway, made it into Canada, and what took place there. And then I'll end with some comments. I listened to an interview this week on CBC Radio with some ladies from the Elizabeth Fry Society of mainland Nova Scotia, as distinct from the Elizabeth Fry Society of Cape Breton. There are two different organizations. And they were talking about an upcoming event, From Grief to Action, and how that relates to intimate partner violence, the treatment by the police and the courts, and just some commentary on the event that they have planned, the interview, and some of the language used there. Just the state of where intimate partner violence is in the courts in Nova Scotia now. So I want to start with this prorogation decision, and this decision from the federal court. This is what the front cover of a federal court or any court decision looks like, and it was brought by when the Prime Minister requested from the Governor General that she prorogue Parliament until late March, the two individuals from Nova Scotia took the Prime Minister, the government, to court and challenged whether the decision to prorogue Parliament, that is, basically put Parliament on pause, where everything that was in play, that was, any committee meetings, any legislation that was being debated, going through the process of, first, second, third reading, all of those things stop and start over again with a new Parliament. There would be a new session. Proroguing Parliament doesn't require that there be an election. You can prorogue Parliament in between elections. All it means is that everything that was happening, any legislation that was being going through the process, stops, has to start over, and it starts off with a new speech from the throne. So it's a way for the government to reset its agenda and stop some things. Like in this case, the Parliament was at a bit of a deadlock over some disclosure motion. Anyway, I don't want to go into that too much, but it was there wasn't much happening in Parliament. Prime Minister decided to prorogue. He was way down in the polls. It seemed like a very political decision. And so these two individuals from Nova Scotia, David McKinnon and Aris Lavranos, took the matter to court, federal court, and the court heard the case on an expedited basis. So that was unusual as well. Who are these people? Well, David McKinnon, he was a lawyer in British Columbia. He was admitted to the bar in Quebec as well, retired now, I believe. And Aris Lavranos, emergency room doctor, also was, at least, and may still be, a member of the Nova Scotia Bar, took the government to court. And the question for the court to decide, and it goes right in the first paragraph of this 96-page decision, which I reviewed today, is at its core, this proceeding concerns the extent to which our constitutional framework contemplates a potential role for the courts to play when the Prime Minister advises the Governor-General to prorogue Parliament. So that's really a big question. Are the courts even, that was the first question, and the government said, no, the courts are not even permitted to ask this question or be involved and make a decision. The respondent, that is the government, said maintains that the courts have no role whatsoever, and the judge immediately says, I respectfully disagree. The courts have a constitutional role. Is it important that it be exercised to maintain public confidence in the institutions of our government? Okay. So the jurisdictional question was answered very clearly, that the government does have a role. It's a decision that's made by a government entity, so it is reviewable by the courts. But the Chief Justice does go to some lengths to describe how, with decisions of this nature, which are in large part political decisions, the courts maintain some distance. There's some healthy, I guess, hesitancy to be involved in political decisions. Now, I had spoken about this before. Actually, okay, so first of all, the release of the decision is very timely, of course, because on Sunday, the Liberal Party of Canada is going to be electing a new leader, and that new leader will become the Prime Minister of Canada. So that's important to know whether Parliament needs to be sitting. Like, if this decision had gone the other way, the prorogation would have been declared invalid, and Parliament would then have been sitting again. Well, this allows that decision to, I guess, continue. We're going to have a new Prime Minister on Sunday, probably Mark Carney by the sounds of it, and then that Prime Minister will make a decision as to whether to go back, to recall Parliament or go into an election. We'll see what happens there. Now, in the decision, the court was certainly aware of the political context involved. They described early on in the decision that there was allegations that this was done for Liberal partisan purposes, that the various leaders of the opposition parties, Francois Blanchette, Pierre Poilievre, and Jagmeet Singh, had all said in one way or another that they would express a lack of confidence in the government. But there was some hesitation about particularly the role of Jagmeet Singh, because the other parties had actually voted in Parliament non-confidence. But the government had survived those votes because of the NDP support. And so, yes, the political context of it all, the Liberals were way down in the polls, they were delaying because of the leadership contest, all these things, yes, sure. But what the court said was, what does confidence in the government mean? In paragraph 232, they say that letters or statements made outside of Parliament cannot be accepted by the court as evidence about confidence. So we know that, for example, the biggest example, Jagmeet Singh wrote a public letter on December 20th, 2024, that he was going to, at the first opportunity in the new Parliament, vote non-confidence in the government. What does the court say about that? That it is not reliable evidence of the House's confidence, House of Commons. So, yes, you can write in a letter, Mr. Singh, but unless you actually vote that way in Parliament, it doesn't matter. It cannot be relied upon. The Chief Justice also made comment that even in that letter, there was no clarity as to actually when that vote of non-confidence may have taken place. And that there was this was a significant point, actually a point that might be appealable if the parties are looking to appeal. The Chief Justice said that there was no legal obligation identified for the Prime Minister to take into account potential non-confidence votes. So many people were thinking of this from a political standpoint and saying, well, we have the Bloc Québécois, Conservative Party of Canada, and now the NDP saying that they are prepared to, and at the first opportunity are intending to, vote non-confidence in the government. Well, that stated intention is not, according to the Chief Justice, legally relevant. It's only what they actually do, and the government survived 3 non-confidence votes in the fall. So the only conclusion that the court was prepared to reach from all that was that the House does or did have confidence at the time. The other big, contextual factor in all this is that there's really not much precedent for any kind of decision like this. So the Supreme Court of Canada has never had to decide whether the Prime Minister can ask the Governor General to prorogue Parliament. There is a very well known, certainly in legal circles, case out of the United Kingdom around Brexit. It's called Miller 2. And it was a situation where Prime Minister Boris Johnson, just as Brexit was about to be ratified, or that they were about to exit the European Union, that the Prime Minister, Johnson, requested from the late Queen Elizabeth that Parliament be prorogued. Well, in that case, the Supreme Court of the United Kingdom said that that was improper, that first of all, that the Prime Minister misled the Queen in explaining why he was seeking prorogation. But it was also a major turning point in the United Kingdom's constitutional, structure, because Brexit was going to take it out of the European Union, require some constitutional changes. There were votes to be taken in Parliament on what the new Brexit agreement might look like, relationship between the United Kingdom and the European Union going forward after Brexit. So there were things that Parliament had to do in that situation, and it was an extraordinary situation that the court said there was unlikely to occur again. So Chief Justice Crampton, I think, properly said this situation does not match that situation. There's, yes, concerns about the tariff threats from the United States, but on that point, Justice Crampton said there is no specifically legislated role for the Canadian Parliament regarding tariffs. They could just happen, and nothing needs to happen necessarily legislatively in response. So that was weighed in favor of allowing this to happen. So for all those reasons, first of all, the court said we shouldn't be interfering lightly in this situation. It is rare that a court would ever interfere with a prorogation decision. It's only happened once, and that was in another country, a country very similar to ours in legal systems. A little different. They have parliamentary supremacy. We have the Charter and the Constitution that can supersede parliamentary supremacy. So it's a little different, very similar. So it was very influential on this court's decision, but this tariff threat from the United States didn't rise to the same level of seriousness as Brexit. So there it goes. So I'd be curious to see if this does get appealed, but regardless, it would only be of academic interest at this point, because by the time anything happens, then it's, we're going to be into the next government and into the next election, all those sort of things. So was interesting, thinking of the political context. The judge early on in paragraph 9 said the applicants alleged that the decision was part of a stratagem designed specifically to interrupt the business of Parliament and stymie the publicly stated intent of a majority of the House of Commons to bring a motion for non-confidence. However, the applicants were unable to establish those allegations. So it's one of these, it's like a Bill Maher joke. He always says, I, I don't know it for a fact, I just know it's true. Well, we know it's true that's why the government sought prorogation, was because of political expediency and priorities. But nevertheless, you can't prove that. The Prime Minister did provide other justifications. The court said the court is not going to probe those other justifications or stated justifications deeply. They're going to prepared to accept them, and so that's how that's going to go. So that's the decision on prorogation. Very interesting stuff for academics and scholars, certainly. Good effort by the two Nova Scotia residents who raised the issue. Interesting decision, but it seemed clear from the start which way that was going to go. It's a political decision. It was politically improper. Here we are with a national crisis on hand, and we don't have Parliament sitting to have proper political debates. All right, so that's what I wanted to say about that. I may come back to that as I delve into it a little more in future episodes, but that's what I wanted to say about the prorogation decision. So those of you that are fans of constitutional issues and arguments may wish, I just got an email today from the Court of Appeal in Nova Scotia that on Tuesday and Wednesday next week, so if you're looking for something to do on March break, the Court of Appeal is going to be webcasting the appeal, it's an early part of the appeal. It's not the main appeal on this question of who should pay for the infrastructure in the Chignecto Isthmus between New Brunswick and Nova Scotia. Lots of political discussion on this, and the government of Nova Scotia is claiming in public and now in court that this is the exclusive jurisdiction of the federal government under their interprovincial trade obligations and responsibilities. So the question that has been put to the Court of Appeal, and governments can do this, right? Normally, if you were a regular litigant, you start at the bottom level, Supreme Court. If you win or lose there, it could go to the Court of Appeal. Win or lose there, it could go to the Supreme Court of Canada. With a provincial government, they can make a reference to their own Court of Appeal. The federal government can make a reference directly to the Supreme Court of Canada on important issues. So this was a reference from the Nova Scotia government to the Nova Scotia Court of Appeal. And the question is the infrastructure which protects the interprovincial transportation, trade, and communications links across the Chignecto Isthmus within the exclusive legislative authority of the Parliament of Canada? In other words, is this federal responsibility exclusively? So the Attorney General of Canada, New Brunswick, and PEI are intervening in this. But this first appeal is not on the main question, but rather whether the question itself is too vaguely worded. Actually, I think the Court of Appeal is going to seek some refinement of that question because, think of it as which protects the interprovincial transportation, trade, and commercial communications links. Well, is that all they are? Is it? Anyway, I suspect this is going to be a decision that kind of guides the way for the rest of the appeal to say it's a mixed responsibility. It has to be. All right, so we'll may watch some of that appeal. I'll be interested to see who the lawyers are involved, how well the arguments are made, and what kind of questions come from the panel. All right, let's get into some other cases and talk. These are all Nova Scotia related. Two of them that related to social media. I guess interaction of social media with court cases. First one involves Facebook, second one Instagram. There's a defamation case, Terrace versus Meisner. Tracy Meisner was the mother of a patient at the Nova Scotia hospital. Patient seemed like a very difficult person, only identified by his initials, MM. And the judgment says he was violent, unpredictable, engaged in biting, defecation, throwing feces. He wore a helmet at all times because he would bang his head against the walls and everything else. The nurse, Miss Terrace, said, this was in 2016, that she was working an overnight shift, which was only 2 people on staff, a lot of trouble, some violent individuals or risks of violence. And this MM, Mr. Meisner, was creating a big disturbance in his room, so they went in, there was feces thrown, it was seemed awful. At one point, an orderly, or more of an orderly than a security guard, but a male orderly came in and put a towel across the face of Mr. Meisner so that he wouldn't spit on the workers, the nurse. Well, Mrs. Meisner got hold of that and made a Facebook post saying that, they put a pillowcase over his head, talked about this, said that, is his shit retarded? Maybe his shit is retarded. She claimed that the nurse said. The nurse never said that. Said maybe his shit is infected. Some other allegations compared her to pedophiles. Said it was violent. Put her photo on Facebook. So Mrs. Terrace did not react to these Facebook posts initially, hoping they would go away. Didn't want to draw coverage to it. By the way, was worried about privacy concerns, and if she said anything publicly about a patient, that she could get in trouble. She was investigated by both the health authority and the nurses union, cleared in both cases. Took a stress leave, dropped out of a master's program, had a part-time federal job, quit that. Had a difficult relationship with her family and others. So Facebook, it took off. The post, of course, you know what it's like. Oh, this awful thing happened. Well, all the keyboard warriors jumped in. Well, that's terrible, and we should get her. And some people were threatening violence, and it really escalated. She was seeking, Miss Terrace. I had a lawyer, Laura Nielsen from Press A. Mason. And Miss Meisner was a self-represented defendant. Bad sign. Bad sign. In these cases, if you're the plaintiff, that is. If you're the plaintiff and you're making a defamation claim, it's different than a lot of other claims. If you're making a motor vehicle claim, if you slip and fall at somebody's house, there's insurance. If you win at court, you're going to get paid. If you win at court against somebody on a defamation claim, there's no insurance. They have to pay it themselves. And if they're going in self-represented, that means they don't have the money to hire a lawyer. They're unlikely. It's going to be difficult to collect this judgment. She did win a $60,000 award, but Justice Boudreau denied the loss of income claim that she was seeking because she said she reduced her hours, quit a job, didn't pursue a master's, could have had higher income in the future. The judge said there wasn't enough evidence of that to make that connection. So that's one trouble with defamation. The other trouble, like I say, is going to be collecting that money. How's it going to happen unless Miss Meisner has assets, a home that she owns, could attach that judgment? It's going to be tough to collect. So that's one social media case. The other one is this Steve Hutchings case that's ongoing. Elementary school gym teacher, has Don Murray as a lawyer, good defense lawyer. This took place 30 years ago, so automatically difficult for evidentiary purposes. Accusations that after school, the complainant had troubles at home, so was sticking around school afterwards, helping out around the gym, and says that Mr. Hutchings would hug her for prolonged periods of time and made some noises while he did so. She admits to memory problems, said made no accusation that he ever touched her under her clothes or anything like that. Peculiar part here. Two peculiar parts. One is she went to another teacher to complain. Well, the teacher was Karen Johnson, Mr. Hutchins' wife at the time, now separated. Some uncertain comments about whether Miss Johnston may have encouraged the complainant to make a complaint to the police after her separation. However, there's also an indication in the CBC story that she might be testifying for the defense, which would indicate that she's prepared to say no. Either the girl didn't really complain to her, or that the complaint wasn't as she is now portraying it. So we'll see what happens there. The social media aspect, though, is that she had, started making these comments on Instagram, and all of a sudden, a few years ago, and all of a sudden this is how Miss Johnston discovered the allegations. All of a sudden she has thousands of Instagram followers, and she's talking more about the allegations, and well, the keyboard, aren't you going to do something about it? Aren't you going to do something about it? Well, what do you say, right? You have to go do something about it if you're going to keep talking. At some point, you've got to go make a complaint to the police. Something that may have been a little uncertain at first, well, once you put it online and put it in public, that if it takes off and you want to satisfy your followers. So if you were the defense lawyer, you'd be looking at that and saying, well, what are you motivated here by? Complaining the situation, or are you trying to expand your following on Instagram? So be interested to see where that one goes. All right, a couple of other quick things. This Kazemi case from Judge Vanderhoek got my attention just because this was I've been seeing some cases and commentary on immigration consequences of convictions. This wasn't quite that way. This is an Afghan citizen, but he is considered a protected person in Sweden. Stowed away. This was his third attempt to get to Nova Scotia, and he had been escorted to Sweden a week before, got on a boat from the UK, came back stowed away on a boat, made it back to Nova Scotia. First of all, I have some questions as to why the Canadian Border Service agents have to fly all the way to Sweden. Once the person's on the plane, what else is there to do? I mean, the plane's going to go to Sweden. Anyway, that's a separate story. Maybe they had some stopovers. That wasn't described in the decision. So he comes back, Kazemi, he gets caught right away, spends 4 months in jail. The Crown, there was some commentary in the case. This also caught my attention. So whenever you're doing these calculations as defense or Crown lawyers of how much time the person has spent in jail, if you spend a month in jail, you get credit for a month and a half. It's a 1.5 calculation for anything pre-conviction, before a guilty plea. Well, you calculate that in days. You don't think in big months terms, right? Because months obviously have different numbers of days. So they were the Crown was recommending 6 months. Well, if it had been 6 months, he would have had to stay in jail for another few days, where the border agents were there at the hearing, ready to take him out of the country. So they had to spend some time, and the judge commented on what a waste of time it was to be recalculating those things in court rather than doing it beforehand. So you should always go into court prepared. The other interesting part of the decision is that Judge Vanderhoek makes comment on the immigration system not being an open door, that Canadian entry into Canada can be considered a gateway entry to our southern neighbor. And so interesting, no mention of the current crisis or anything like that, but I wondered if the judge was thinking, we have to be extra tough as judges on people in immigration situations if they're going to be seen to exploit this. And here's a quote that you can provide to the U.S. government to say that, hey, our courts are trying their best to keep people from sneaking into the States through Canada. Okay, so last thing I wanted to mention, this is not really a case, but the Mass Casualty Commission talked about intimate partner violence. Desmond Inquiry talked about it as well. some changes we thought might be forthcoming from the MCC on changing the way it's treated by police and courts. Nothing like that has really happened, but of course there's been I think 6, 7, 8 murders in Nova Scotia already this year in intimate partner violence situations. And the Elizabeth Fry Society is holding an event called From Grief to Action, where they're going to have victims and family members of victims come in and speak. They're on CBC Main Street Wednesday afternoon, and I wondered if some of the language used by advocates might be having the opposite effect, or might be holding things back. The word conversation was uttered maybe 20 times during this 12, 13-minute interview. We have to have conversations. We have to have difficult conversations about these things. But at least the interviewees, and I wonder if this is the case at the conference as well, I'd be curious to hear, won't speak plainly about what is taking place. These are the kinds of phrases they use. Well, intimate partner violence itself is a bit of like nobody in real life uses these phrases. Coercive control, this is something that's becoming more known. And they say that it's a new term and they need to build awareness about it, but they're trying to criminalize coercive control. So if you're trying to criminalize something which most people don't even understand what it is, maybe you're going a little too quick with certain things, or just don't use the term. Lived experience, an anti-oppressive approach to coercive control. Do you know what that means? Multifaceted outcome. What does that mean? The intersection of gender-based violence and criminalization. Criminalization of victims, reactive violence. Like, just say what you really mean instead of coaching it in these terms that are sort of safer. They sound like consultant speak kind of terms. Just say what you're really talking about. People are not so sensitive. They'll they'll listen to plain language if you're willing to use it. So, overlap in experiences, compounds to increase vulnerability. Like, just say what you really mean. Talk about what actually happens in these cases. I think would be of service to the victims and would lead to change quicker than sort of talking around the edges of it. So we'll see what happens. I'd be happy to be part of that conference or speak to these topics at any point. So, all right, that was the week in Nova Scotia. I hope everybody enjoyed that. I'm going to get on this more regularly now that I'm back doing Rogers Brief episodes. Another programming note, also going on with Paul Palango on Sunday evenings with the Dispersing the Fog podcast he and I are doing. That sort of continues some of the police, political, legal discussions that we've been having for a long time, he and I. So join us there at 8:30 Sunday night on YouTube. All right, hope everybody enjoys the March break. Enjoy your weekend, and we'll talk to you again next time.